everybody, Pamela here, and today is going to take us more than a minute. Today we are going to talk about a very complex issue, which is grandparent visitation. And there's a lot of family law attorneys that don't even want to touch this because it can be quite difficult to establish what you need to establish in order for grandparents to get visitation. First off, I'm going to be talking about situations where the parents no longer are together. They live separately and apart, either because of a divorce or a parentage case. The grandparents are going to go to court and file what's called a joinder to become part of that case so that they are essentially parties and the court can make orders against them or for them. They are then going to petition the court for grandparent visitation. So with grandparent visitation, there is a case that is a U.S. Supreme Court case, and it's called Troxel versus Granville. Troxel versus Granville, and this is a case that came out of the state of Washington, but because it's a U.S. Supreme Court case, it applies across the United States. And this basically established that most fit parents are going to be given discretion when it comes to what visitation they will allow with grandparents. So again, when we're talking about fit parents who are able to make these types of decisions in the best interest of their children, the court is going to presume that they are doing so, and they're not going to mandate a set visitation schedule. Now, the grandparent can still file in a divorce case or in a parentage case a joinder to be added as a party, and then a petition for visitation themselves in that case through a motion. And when they do that, they can then rebut the presumption, right? They can show that there is a very deep-rooted type of relationship that they have with their grandchildren, that it would be not only in the best interest of them, but most courts, even though the code is worded best interest of the children, most courts do want to see that not having some type of established visitation schedule when there are fit parents involved was essentially a detriment to the child because they've lived with the grandparent in the past or something like that. That is a very deep-rooted situation. There are quite a few family code sections that are going to apply to grandparent visitation. You're going to want to check out California Family Code 3021, California Family Code 3103. 3103 is what grants the court the authority to make non-parent relative visitation available once they're made a party to the action. And you're also going to want to check out Family Code 3104. Again, it's very important to note that there is a Family Code 3102 that applies where one of the parents is dead. They're still going to give the remaining parent, the remaining living parent, a lot of discretion. And typically, if in any of these situations, the parents are allowing some level of visitation with the grandparents, typically the court will allow them to mandate what the type of visitation that is occurring, and typically the court will not make orders to a set schedule. So you want to make sure that if you are a grandparent, you definitely hire an attorney for this. It is a very complex aspect of family law, and it's not something that everyone has a great understanding about. So make sure you talk to someone who has dealt with this before. Good luck.